Good evening, ladies and gentlemen. My name is Paul Dennis, and I'm from the British Virgin Islands law firm of O'Neill Webster. I have been practicing in the BVI for the last 20 years, in fact, in my 21st year, during which time my practice has encompassed the entire range of commercial litigation, including corporate insolvency and the wide gamut of asset tracing and recovery related issues which are relevant to this conference. A little later I will give, starting off the discussion this evening, a brief overview of some of the issues and challenges which we've faced from a BVI perspective, because of course that's where I practice, in terms of trying to assist those who would seek to recover the proceeds of fraud which may somehow have found their way into BVI entities. I will also look briefly at some of the ways in which, through creative judicial intervention and legislative initiatives, we have been able to overcome and surmount some of those hurdles.
Hello everyone, my name is Nicholas Fox. I'm an insolvency litigator working out of the Mourant Ozannes office in the Cayman Islands. Mourant Ozannes is a relatively large offshore firm with offices in the BVI, Cayman, London, Jersey, Guernsey and Hong Kong. In Cayman, our litigation team has over 20 fee earners. I'm going to talk about two subjects that relate to interactions between onshore and offshore liquidations, namely the Madoff Victim Fund and the Fletcher and Soundview Fund decisions.
Afternoon, Hugh Dickson. I'm the managing partner of Grant Thornton's offshore insolvency operation based in Cayman. I also oversee our operations in the BVI as well. And I've been asked to talk about in duplicate apparently, about the conflicts that arise between onshore and offshore, with specific reference to law enforcement and in particular reference to the Department of Justice's actions in the United States in relation to the Stanford International Bank case. I think with that, back to you, Paul.
Yes. I should just add, in case you're interested, there is an insert which you will find on the tables before you with further details of myself and my firm in case you are interested in that additional information. Now, at this time of the day, particularly after full sessions and after a generously heavy lunch, the last thing I'm sure that anyone wants is a long legal discourse, because that will only lead to what we euphemistically refer to in the Caribbean, at any rate, as ethnic fatigue. I have a colleague who had a classic way of dealing with this when he had to address an audience after lunch, and he would have everyone in the audience draw a sketch of the person next to them and then pass those around. Needless to say, the result would be so hilarious that everyone would instantly wake up. I'm not going to ask you to draw any sketches this afternoon, but I would crave your indulgence for a few brief minutes as we look at some of the, in particular, some of the jurisdictional challenges which clients typically tend to face in seeking to launch proceedings or applications in an offshore jurisdiction such as the BVI, which ultimately would have as its objective the recovery of assets which may have found their way there. These I will look at in three broad categories very quickly. The first has to do with satisfying the criteria for service of proceedings outside the jurisdiction of a claim launched in the BVI. Second, I will look briefly at some of the jurisdictional hurdles to the grant of injunctive relief, and I think here in particular of freezing injunctions for the protection of assets pending litigation. I will also look briefly at ways in which the scope of Norwich Pharmacal type discovery reliefs have been expanded in the BVI. And finally, very briefly, on legislative initiatives which now make it somewhat easier for foreign representatives of companies which are in liquidation overseas to be able to obtain recognition from the BVI courts. Beginning first with the question of service out of the jurisdiction. Up until quite recently, the regime in the BVI for service out of the jurisdiction was quite narrowly constrained by the requirement to satisfy certain specific criteria in order to obtain such leave for service out of the jurisdiction. And in particular, this led to difficulties quite often when parties were seeking to obtain freezing orders for assets which may be located in the BVI, but in respect of which the underlying litigation had no actual connection in the BVI or was not being pursued there. And that difficulty arose in particular because of a principle which came to be regarded and commonly known as the Siskina principle, so named because of the UK authority in which the issue arose. And essentially, the effect of the Siskina principle, without going into the details of the case, is that the court would not grant a freestanding injunction unless that injunction was being made in support of a claim which the court in the BVI had jurisdiction to enforce by final judgment. In a nutshell, in order for you to obtain that kind of injunctive relief, you would first have to be in a position to obtain leave to serve out of the jurisdiction, which meant you had to have a substantive claim justiciable in the BVI. This led to all sorts of difficulties, and a typical situation in which that would arise is exemplified by an early case in the 1990s in which I was involved in the BVI, Floyd Koch and Robert Chow, in which the court refused a freezing injunction against assets in the BVI. It did so because following the Siskina, there was no substantive claim justiciable in the BVI to ground the injunction, and the location of the assets in the BVI was not considered to be enough, so that the tracing claim on the basis of which the court's jurisdiction was sought to be invoked, which was a claim in the United States, was not sufficient to ground the grant of the injunction because it was not the kind of claim for which service out of the jurisdiction could have been obtained. So that the litigant in that particular case was left up a creek without a paddle, so to speak, and therefore was not in a position to obtain the relief which was necessary in order to protect those assets. This remained the position for a very long time, and the first inroad into that approach was made in the more recent case in the BVI, which arose in 2010, the case of Black Swan Investment SA against Harvest View Limited. And again, without going into the details of the Black Swan case, what essentially it happened was that the court, the commercial court in that case, granted a freezing order to protect assets in the BVI in aid of proceedings abroad to enforce a money judgment, notwithstanding the absence of any substantive proceedings in the BVI itself. That was a clear inroad into the Siskina principle. But the court rationalized it on this basis. It mattered not that there was to be no substantive proceedings against the defendant in the BVI. What was important was the fact that the cause of action on which the freezing application was based was known to the jurisdiction. And although there was no substantive proceedings even contemplated in the BVI, the defendant, being a BVI company, was already subject to the territorial jurisdiction of the BVI court. And so, for the first time in that kind of situation, the freezing injunction was granted. So, as a result of Black Swan, the position was that once you could show that the cause of action, which grounded the application in the foreign jurisdiction, was one known to BVI law, and the defendants was subject to the jurisdiction of the BVI court, the relief would be granted. And then there was another development on Black Swan, which arose a year later in another case, the case of UCOS CIS Investments Limited and another, and UCOS Hydrocarbons. Now, that was a decision of the Court of Appeal, the Eastern Caribbean Court of Appeal, on an appeal from a decision in the BVI. And again, without going into the details of the UCOS case, essentially the effect of that case was to make it plain that not only will the court grant a freezing injunction in respect of assets against which the applicant may, if he succeeded in the foreign court proceedings, be able to enforce a money judgment, but rather the relevant inquiry was whether or not the claimant may obtain a foreign judgment which may be enforceable by whatever means. So that, as it were, expanded the jurisdiction even further, building on the Siskina. And interestingly enough, the judges who were involved in both of those decisions are present at the session and were in fact on the judges' panel this morning. The Black Swan case was in fact decided by none other than Justice Bannister of the BVI Commercial Court, and Justice Cowley, sitting as an appellate judge on an appeal from the BVI court, actually delivered the decision in the UCOS case. And as Justice Bannister put it, underlying the Black Swan decision, there are sound policy reasons why important financial centers, such as the BVI, should be in a position to grant such orders in aid where necessary. Speaking here about Mariva-type injunctions to protect assets. The business of companies registered within such jurisdictions is invariably transacted abroad, and disputes between the parties who own them and others are often resolved abroad. It seems to me that when a party to such a dispute is seeking a money judgment against someone with assets within the jurisdiction, it would be highly detrimental to its reputation if potential foreign judgment creditors were to be told that they could not, if successful, have resort to such assets unless they were to commence substantive proceedings here in circumstances where, in all probability, they would be unable to obtain permission to serve them abroad, thus presenting them with an effective brick wall. So that effectively one can say, in the aftermath of those authorities, the current position in the BVI is that the court will indeed grant a freezing injunction or indeed receivership orders in aid of foreign proceedings if the claimant is likely to obtain from the foreign court a judgment which would be enforceable against the respondent's assets within the jurisdiction. So those two cases are just a small example of the way in which an appropriately creative judicial approach would further the ends of justice by assisting those who would seek to protect assets which fall into the hands of fraudsters. Now, since these cases, there have been further initiatives in the BVI which have in fact expanded the scope of cases in which service out of the jurisdiction will be obtained, so that to some extent those difficulties have been largely ameliorated. And I'll just mention two of them here in particular in relation to claims against companies, it used to be that BVI litigant who wanted to pursue foreign defendants who had interests in BVI companies, ultimately with the objective of recovering assets, would not be able to satisfy the service out requirement unless they could show that there was some real issue to be tried between the litigant and the BVI company involved. This was often very difficult because in most instances the litigant would have no dispute with the company, but with those who controlled it or who spirited away its assets. And so that created quite a bit of difficulty. The jurisdiction for service out, however, has since been expanded to include all claims which are concerned with the constitution, administration, or management or conduct of the affairs of a BVI company, or the ownership or control of BVI companies. Also now added as a claim which will be amenable to service out of the jurisdictions are claims for restitution in circumstances where it can be shown that the claim for restitution is being made where the defendant's alleged liability arises out of acts committed within the jurisdiction or out of acts which, wherever committed, were to the detriment of a person domiciled within the jurisdiction. And finally, there has been legislative expansion in the BVI in recent years for the enforcement of foreign judgments and awards. Initially, such enforcement was only possible in relation to judgments or arbitral awards made within the BVI. This has now been expanded to include judgments or arbitral awards made by a foreign tribunal. So that's an example of legislative intervention to surmount some of the hurdles which litigants may otherwise face. And then very briefly, some of the other issues, Norwich Pharmacolaw discovery relief, and those of us who have a English common law background would be very familiar with the Norwich Pharmacolaw relief, which basically allows a litigant to obtain pre-litigation discovery orders in order to determine who are the persons who may be mixed up in fraud, so as to obtain information in order to pursue them. And for quite some time in the BVI, the position was that one could not simply obtain such a discovery order against registered agents simply by virtue of the fact that they were registered agents. One had to go further to show that the registered agents were somehow mixed up in that fraud. And the mere fact that they were providing registered agent services for the companies was not sufficient. And so that was consistently the position, and that again led to difficulty in terms of obtaining that kind of information. However, again, recent judicial authority has made significant inroad into that position, and in particular, the case of JSC BTA Bank, in which the Court of Appeal essentially held, again without going into the details, that the fact that a company was, that a registered agent was providing those services for a company should, without more, make it subject to these discovery orders. It wasn't necessary to show that, quite apart from providing registered agent services, it was in some more direct way connected to the alleged fraud. And essentially, the rationale is succinctly summarized in one passage from the judgment of Justice Mitchell, where he said registered agents and registered office service providers who are used by others to create and maintain for them corporate vehicles for the purpose of effecting fraud must expect that in due course the victims will come to them seeking recovery of the names and addresses and other information and documents that will enable the perpetrators to be discovered and the misappropriated assets traced. And so that now is another arsenal, another weapon in the arsenal of those who are trying to trace assets and discover information. And finally, in terms of recent legislative initiatives to improve the position of foreign office holders, particularly in insolvency proceedings, there have been initiatives in the BVI to address this as well by two new significant provisions in the Act. The first one deals with cross-border matters, and this really is an enactment of the UNCITRAL Code, which proceeds on the basis of permitting persons appointed as bankruptcy trustees or liquidators of insolvent estates to apply to the BVI court to have those proceedings recognized. Formerly, recognition was pursuant to the common law, which was very limited and provided accordingly only very limited relief. It is a precondition for recognition that the foreign insolvency proceedings are being conducted under the control or supervision of a court within a designated jurisdiction. And once recognition is granted, the bankruptcy trustees or liquidators may apply to the BVI court for a variety of reliefs designed to enable them to act in the BVI as if or substantially as if they were locally appointed liquidator or bankruptcy trustee. This part of the new legislation has not yet actually come into effect, but we expect that it will hopefully sometime in the near future. The other aspect of this initiative deals with orders in aid of foreign proceedings. And under this part of the legislation, a foreign representative appointed to act in a relevant foreign country may apply to the BVI court for an order in aid of the proceedings in which he is appointed. The fundamental difference between this part and the part which has not yet come into effect is that Part 18, which has not yet come into effect, confers status or would confer status on the foreign representative through the recognition of the foreign proceedings in which he has been appointed, whereas Part 19 merely gives a foreign representative from a relevant country express rights to apply to the British Virgin Islands courts for orders in aid, but without conferring status. The designated countries is defined as those countries which are so granted that status by the BVI Financial Services Commission, and to date 9 countries have been so designated, and these are Australia, Canada, Finland, Hong Kong, Japan, Jersey, New Zealand, the United Kingdom, and the United States of America. So that now under this new provision, the court has discretion to make, among other things, orders to restrain the creation or exercise or enforcement of any right or remedy over or against any of the property of a debtor in the BVI, to require any person to deliver up to the foreign representative any property of the debtor or the proceeds of such property, and to make such order or grant such relief as it considers appropriate to facilitate or approve or implement arrangements that will result in a coordination of a Virgin Islands insolvency proceedings with a foreign proceeding. It also authorizes the foreign office holder to examine in the Virgin Islands a relevant debtor. And the court has wide discretionary power to make basically such order as it grants fit or as it considers appropriate pursuant to those provisions. In determining such an application, the court is enjoined to be guided by what will best ensure the economic and expeditious administration of the foreign proceeding, to the extent consistent with, among other things, the just treatment of all persons claiming in the foreign proceedings, and the protection of persons in the Virgin Islands who have claims against the debtor, against prejudice and inconvenience in the processing of claims in the foreign proceedings. Now, I know that that has been quite a mouthful, and I've tried to get through it as quickly as possible. But that's a quick overview of both legislative and judicial initiatives which have sought to improve the position of litigants seeking to recover the proceeds of crime. And as the discussion goes on, it will be interesting to see whether participating members from other jurisdictions may have had or may still have to grapple with some of these issues, and they may be interested in sharing with us as to how their courts and the powers that be through legislative intervention have sought to address these. Thank you.
Thanks for that, Paul. There's some nice examples there of the opportunities for cooperation, collaboration between jurisdictions where suitable circumstances arise. Now, of course, the title of the talk is Where Offshore and Onshore Collides, and my example is perhaps a little less harmonious. In particular, it relates to the case of Stanford International Bank. Now, for those not familiar with the case, Alan Stanford set up the bank originally, other than Antigua, he moved it to, it was originally incorporated, I think, in Montserrat, moved to Antigua latterly, and he then proceeded to run a very successful fraud for some number of years. Alan's primary instrument of choice was selling certificates of deposit that bore above market rates of interest, and then used the incoming proceeds to repay his original depositors, a fairly well-established mechanism. During the course of his activities, he sold some $10 billion worth of CDs, and the total capital loss in the fraud is something like $5 billion. When insolvency practitioners were eventually appointed, there's some 22,000 depositors out of pocket across 113 countries. Interestingly enough, the SEC first started investigating Alan Stanford in 1997, and they subsequently launched further investigations in 2002 and 2004, but it wasn't until 2009, February 2009, that they appointed a receiver, and indeed the Antiguan government appointed a receiver and manager in Antigua and Barbuda, followed by the appointment of liquidators in April 2009. Now, the particular issue I'm talking about is the conflict with the law enforcement community's activities in trying to deal with Mr. Stanford. The Department of Justice issued a series of MLATs and freezing orders starting in April 2009. I think their first freezing order in the UK predated the appointment of liquidators, but postdated, of course, the appointment of receivers. And they then proceeded across the UK, Switzerland, and Canada to freeze some $345 million in a combination of cash and financial instruments held in those jurisdictions. For those interested, 110 in the UK, just over 200 in Switzerland, and approximately 20 million in Canada. We were appointed as liquidators, so Marcus White and myself and our BVI office were appointed as liquidators in May 2011 following a change of liquidator. And it was apparent fairly quickly that these freezing orders had fundamental consequences on insolvency practitioners' ability to actually properly conduct that estate, probably the law of unintended consequences. A number of fairly obvious, I suppose, with benefit of hindsight problems. Firstly, there's no liquidity left in the estate. All the cash and immediately fungible assets have been locked up. Because of the freezing orders, it's extraordinarily difficult to actually move money through the international monetary system in US dollars. You couldn't transit money through New York because it would get locked up. And there'd be no management of the assets. These assets weren't just cash sitting in bank accounts, they included investments and things like hedge funds. And they've been frozen, so the investment managers couldn't deal with them, they couldn't redeem, they couldn't sell positions that were deteriorating, they couldn't meet capital calls, just completely locked up and eroding. You might ask, what then is the genesis of any difficulty between the law enforcement agents and the insolvency practitioners? cooperating and collaborating. Why, for example, doesn't the Department of Justice say, well, we've done our job in freezing these assets, here's an officer of the court that's been appointed, and hand over the assets to them? Well, it became pretty apparent to Marcus and myself that there's some fundamental differences, cultural differences, if you like, between law enforcement and insolvency practitioners. It probably starts with a suspicion of professionals and the private sector as motivation. I think it's not unfair to say the Department of Justice thought that the professionals involved in the case were simply there to convert the frozen assets into professional fees with the minimum of interruption in the process, and had no interest whatsoever in victims. There's also fairly apparently a degree of what I might call offshore prejudice. DOJ takes a view that if it has offshore associated with it, it's somehow inherently corrupt or crooked. In fact, one individual even went so far as to say to Marcus and myself, your creditors are all drug dealers, money launderers, or tax evaders, which I think is a fairly sweeping statement. It's probably not as bad as saying that 37,500 Chinese companies are all engaged in corruption in the BVI, but it's not far off it. Also in the cultural nexus issue, the Department of Justice has an asset confiscation forfeiture system. The US government does. It's originally designed to deal with, kicking down a drug dealer's front door and taking his assets, his Ferrari, and the available cash that was lying around the table, and recycling it for use by law enforcement. It's not really designed to deal with multi-billion-dollar estates or hundreds of millions of dollar estates. It's a straight victim, not a victim-centric system. Now, they will tell you they have an ability to distribute money to victims, a victim compensation system, but it's very, very simplistic. And if you look at it as a claims process, basically they pool the cash and they invite people to claim against it. But there's no judicial oversight of claims adjudication or distribution. There are real practical mechanisms that raise a real risk of particularly offshore or overseas creditors not being able to claim without losing their confidentiality, for example. It's demonstrably not independent. The only appeal against a determination on your application to the Victim Compensation Fund is to appeal to the same people that made the decision in the first place, albeit a different department within the Department of Justice. And the allocation of the resources is not necessarily consistent with the governing law of the jurisdiction of incorporation. So you wouldn't have a waterfall of claims respected. You'd also have admission of people who are not necessarily creditors of the same estate, for example. Another problem that becomes apparent is conflict of interest. One of the biggest individual creditors in the SEC receivership in the Alan Stanford case is the IRS for taxes assessed on Alan Stanford's illegal activities. We asked for a categoric assurance from the Department of Justice that if we were to walk away from conflict, the dispute over who should have access and control of this money, that the US government would categorically not touch a penny of it, as opposed to, for example, asserting a priority claim against it and swallowing the large, if not all, the money. And the DOJ said they were unable to give us that assurance in writing, but clearly of course they wouldn't do that. But they couldn't give us an assurance that they wouldn't, a binding assurance, because apparent difficulties or differences of opinion between themselves and the Treasury. Where this all ends up with, of course, is a very unfortunate situation in which the insolvency practitioners, really acting in the fiduciary interests of the creditors, have little option but to take on a law enforcement department and fight them for control of the money, with a consequent delay of several years in actually distributing funds, the incurrence of significant non-productive legal costs in recovering that money, and an atmosphere of hostility and conflict rather than one of cooperation in which both sides can assist the other. For example, it became apparent that DOJ didn't have access to all the information they needed to properly prosecute Alan Stanford, and the insolvency practitioners could certainly assist with that. And equally, we didn't necessarily have access to all the information they had that would have enabled us to better trace and pursue assets. Cutting a long story short, after some extended legal skirmishing and proceedings, we eventually reached the terms of a settlement, both with the Department of Justice and with the SEC receiver, in which there was a division, if you like, of the frozen monies. For those of you who are interested, approximately 215 million of the frozen money was agreed to come to the hands of the Antiguan liquidators, and about 130 million to the SEC receiver. But with the exception of some 36 million, which the Antiguan liquidators ring-fenced for the purposes of managing the estate and conducting litigation, all that money was agreed to flow through to the victims. So it was ring-fenced for the purposes of passing on to the creditors, which went a long way, I think, to reassuring the DOJ's concerns that the monies would simply be gobbled up in the costs of running the estate. I think my takeaway from it all was that there must be a way of doing this better next time. It seems wholly unproductive for IPs, onshore or offshore, to be fighting with the agencies of law enforcement. There must be better ways for them working cooperatively, because at the end of the day, we're both meant to be the guys wearing the white hats and not shades of grey. I think with that, I will pass on to Nick, who's got some observations on a related set of issues on onshore-offshore conflict.
Thanks, Hugh. Oh, I see my slides are up. Good. Everyone, I'm aware that I'm the last person standing between you and cocktails, and also that goes equally for myself, so I'll make this relatively quick. Two subjects for my talk today. The first is the Madoff Victim Fund, which, as most of you will know, was set up by the US Department of Justice and has over $4 billion to distribute to victims of the Madoff fraud. One of the big differences between the Victim Fund and the SIPA liquidation of Madoff's business is that the Victim Fund expressly aims to provide compensation to people who invested into Madoff indirectly, such as through an offshore fund. As the Special Master notes on his website, most of the money from indirect investors flowed through a number of offshore vehicles, and several of those funds funneled billions of dollars into Madoff's business. Now, as matters stand, most, if not all, of those large funds are presently in liquidation in their respective home jurisdictions, with, as Hugh mentioned, independent professionals appointed over them who are duty-bound to try to recover and distribute the maximum possible amounts of money to their creditors and investors, the same victims that the Madoff Victim Fund wants to distribute to. Notwithstanding this position, the Special Master has chosen to deal with the underlying investors, the underlying victims, directly. The stated aim on his website is to avoid any potential diversion of recoveries and to prevent funds from being affected by insolvency proceedings or litigation involving the feeder funds. Now, an alternative approach, you might have thought, might have been to identify at least the 4 or 5 largest feeder funds in liquidation, which upon the trustee's own view have billions of dollars of investments into Madoff, and to engage with those liquidators to agree terms upon which they could ring-fence and distribute a minimum amount of all monies remitted to them by the victim fund in a matter compatible with the victim fund's objectives. The decision not to take that approach might reflect some of the cultural issues Hugh mentioned before. The question that I pose is whether or not bypassing the offshore funds and dealing directly with victims is the best approach. And one way to measure that would be whether or not, in the due course of time, it maximizes the amount of money distributed to victims. That, in turn, will depend upon the cost and efficiency of the claims process. And on its face, the claims process that's been set up might sound straightforward. Any victim must provide full disclosure of all their Madoff-related investments, including all deposits, share purchases, withdrawals, and share sales, so that the Special Master can calculate their overall net loss across all investments related to Madoff. But one concern is whether or not this process might actually be quite difficult to administer in practice. Why? Well, let's take a number of examples. Example number one, your average individual victim may not have all of the necessary information he or she needs to put in claims. Take, for example, someone who invested into a fund or a fund of funds with a variety of underlying investments, not exclusively with Madoff. Now, one may ask, how is that victim going to be able to prove which of his losses and profits are related to the fund's Madoff investments as opposed to the other ones? There's also a risk of fraud. What if you have an individual who invested into two feeder funds, made a profit from one, and made a loss from the other? How is the DOJ going to detect any failure to disclose the profit-making investment and only a claim in respect of the loss-making one? The Victim Fund website says that victims should look to their investment vehicles for assistance, but that isn't entirely straightforward either. Many people will have invested through financial institutions and therefore won't hold their shares in the feeder funds directly. Therefore, a liquidator, if approached for assistance, and I'm aware that this happens quite often, will have limited or no information relating to the positions of individual underlying investors, and therefore, although they might want to help, they may not be in a position to be able to. In addition, at least at present, there appears to have been no mechanism put in place that when distributions eventually fall to be made, to notify feeder fund liquidators of those distributions made to people identified as their investors. In the absence of such a setup, there is a risk of double recoveries by some victims at the detriment of others. Now, the initial claim bar date was the 28th of February this year. That's been extended to the end of April that's just passed. The press release announcing the extension alluded to the complexity of claims, including the fact that often investments flow through 3 or more intermediary vehicles. It's only once claims start to be adjudicated that we'll be able to see the extent to which those potential difficulties impact on the actual time and cost required to resolve them. Only then will it be possible to form a view as to whether or not some measure of increased cooperation with offshore office holders might have been or might still be preferable going forward. The other topic I'd like to touch upon briefly relates to the Fletcher funds, which is a series of funds incorporated offshore and in Delaware and managed out of New York by an individual named Alphonse Fletcher Jr. and his firm Fletcher Asset Management. Now, in 2012, the Cayman liquidators that I act for spent a good part of their year trying to wind up various funds in a multi-level master feeder structure, including the Bermuda Incorporated Master Fund. This is standard practice. In the ordinary course, there are clear advantages of having one set of office holders appointed over all relevant companies if conflicts don't arise. Amongst other things, it enables assets to be secured, a complete investigation by one set of people of all relevant documents, witnesses and facts, and coordinated litigation efforts. By contrast, multiple office holders can lead to the risk of increased costs, because each office holder has to get their own independent advisors, fewer economies of scale, because certainly some documents and witnesses can't just be examined or read by one office holder to the exclusion of all others, but there will be duplication as more than one set of office holders has to read the same documents. There's also the risk of conflicting objectives, personality clashes, and less than total cooperation. Now, in our case, the Bermuda winding up petition had been filed, and those proceedings were well on foot when the Master Funds Management filed for Chapter 11 bankruptcy in the US without prior warning to the Bermuda court or anyone else. What followed from there were several months of litigation before Judge Gerber in the US Bankruptcy Court for the Southern District of New York, where essentially the incumbent management tried to persuade the court that they should be allowed to remain in control of the master fund, either to effect a restructuring or an orderly liquidation. And my client liquidators tried to convince the court to step back and allow liquidation proceedings in the master fund's home jurisdiction to continue. Eventually, perhaps seeing the way that the things were going with them in the US, the incumbent management abandoned their efforts to remain in control and instead took the fairly unusual step of applying for their own replacement by a Chapter 11 trustee. Fortunately, in our case, the trustee that was appointed has been very sensible and pragmatic and cooperative, and there's been a very good degree of cooperation between him and the Cayman liquidators. That's enabled the trustee to produce an extensive report highlighting numerous concerns about the behaviour of the former management. But what we, particularly I at the time, found quite interesting is the fact that the incumbent management clearly regarded the appointment of more than one different office holder as being in their best interests. And if one were to take a slightly cynical view, you might suspect that part of their motivation was to prevent one set of office holders pursuing a unified focused set of investigations and litigation efforts, and that their hope was that the more office holders injected into the process, the greater chances of conflicting objectives, limited cooperation, increased costs. And this is, of course, against the background that if a liquidated company runs out of cash, then whoever's appointed over it, it's very difficult for them, absent sources of outside funding, to pay for investigations or recovery efforts, which may at the end of the day mean no legal claims can be brought against former management, no matter how egregious their behaviour might have been. Now, last year, unpaid redeeming investors of another set of Fletcher funds, named the Soundview funds, presented winding up petitions in respect of them in their home jurisdiction of the Cayman Islands. That claim was brought upon the basis of insolvency because the funds hadn't honoured redemption requests. Also, the funds hadn't produced NAVs or filed audited accounts for several years. They appeared on the evidence to have paid excessive management fees based on inflated NAV in prior periods. And there was also a question of whether some of their assets had been misappropriated. In the Cayman proceedings, the Soundview funds had no answers to the petition. The outstanding sums were clearly owing, and there was no explanation as to why they hadn't been paid. However, on the evening before the winding up petition was due to be heard, the same Fletcher management team again filed Chapter 11 proceedings over those companies in the US. Their Cayman counsel then argued to the Cayman court the next day that the US automatic stay should prevent the Cayman court hearing the petition regarding the Cayman companies until the relevant petitioners had reappeared before the US court to ask for the stay to be varied. Now, the Cayman court gave these arguments fairly short shrift. As can be seen in this slide and the next slide, it focused on the fact that the Chapter 11 proceedings were self-executing, so there's no gatekeeper or threshold to get past in order to be able to file them, and that the defendant's intention in filing them was merely to trigger the automatic stay. The Cayman court concluded that the facts of the case indicated a need for the US court to recognise the appointment of the liquidators in Cayman, the effective date of which would predate the filing of the Chapter 11 papers. However, when the case came before Judge Gerber in the US Bankruptcy Court in January of this year, he took a different view. He accepted the Cayman liquidators' argument that the explicit purpose of the Chapter 11 filing had been to take advantage of the automatic stay to block the imminent appointment of the liquidators. However, he rejected the liquidators' application to dismiss the Chapter 11 filings for cause, finding that the filing actually did still have a legitimate purpose. That decision appears to have been based upon the court's acceptance of the incumbent management's evidence that their own belief, their own genuine belief, was that they were actually better placed to sell certain liquid assets than the Cayman liquidators would be. On that basis, the court declined to find that the filing was motivated by bad faith or to dismiss it. It then proceeded to appoint a Chapter 11 trustee, ruling on a motion that it had actually previously invited the US Trustee's Office to make, and a motion which appeared to have no creditor support on the time. The decision appears to have been largely influenced by the court's view that a trustee was necessary to conduct the relevant investigations and litigation that had to take place in New York, together with a finding that the fund's comey was, at that moment in time at least, in New York itself. In appointing the Chapter 11 trustee, the court emphasised that this relief would not always be available in other cases. So, taking a step back to consider the implications of this type of case going forward, this was a case where the Cayman companies had independent officers appointed over them, albeit that there were some US law-related issues to recognising that. The company's creditors supported the recognition and continuation of the appointment of the existing liquidators as sole office holders. On the other hand, the Chapter 11 filing was made by people against whom there were clear concerns of fraud, with the explicit and recognised purpose of frustrating the Cayman winding up. Against that background, one might have thought that the management's evidence that they held genuine views, that they were indeed the best people placed to sell certain assets, might have been dealt with a fair degree of scepticism. By not dismissing this sort of filing on the grounds of bad faith, this ruling risks encouraging defensive tactics in the future of anybody with sufficient connections with the US, if they're facing winding up proceedings in other jurisdictions, filing defensive Chapter 11 papers in order to frustrate proceedings regarding companies in the home's jurisdictions. If incumbent management regarded as in their interest to frustrate an offshore liquidation, or perhaps if they don't get that lucky and at worst take steps that result in a second office holder being appointed over those companies so that there's decreased chances of cooperation and perhaps increased chances of cost running the assets down, then my suggestion is that the courts might want to be wary about allowing their processes to be manipulated by such parties filing papers and enabling those results to be achieved. This is especially the case given that not every Chapter 11 filing will actually result in the appointment of a Chapter 11 trustee. In any case where that doesn't happen, what in effect management may have is a free shot at disrupting overseas liquidation proceedings in order to remain in control of the company and its business. And I suggest this is a potentially concerning development. And no doubt all eyes will be on the next bankruptcy court determination that has to analyse a Chapter 11 filing in these or similar circumstances. Thank you.
Thanks very much indeed, Nick. I'm conscious we are now, in fact, into cocktail hour. So with that in mind, panel will happily take questions. I'll remind you, Paul commented on the opportunities for collaboration between jurisdictions. Mine was limited to issues of law enforcement and the need for improved cooperation, I think. And then Nick, some interesting parallels with the Madoff Victim Compensation Fund and our favourite subject, offshore cooperation with New York and on chapters. So with that in mind, any questions from the audience? Seems to be consensus. The only question is, why are we still here rather than at the bar? So on that happy note, thank you very much for your kind attention and apologies for the technology.